No problem, thanks.
The Uber Eats guy. He's like, I knew it was unbelievable.
I saw something on the History Channel recently, and it got me thinking. Well, it was probably history.com, but it got me thinking about how we're hearing more and more about the potential changes for our country based on the recent passing of Supreme Court Justice Ruth Bader Ginsburg, RBG, and the nomination of Amy Coney Barrett, who some are already trying to call ACB. Let's let her earn it, okay? My name is Amir Afsar. I'm a California licensed attorney, and on this episode of UNBILLABLE, we're going to cover the landmark, but all things considered, relatively recent Supreme Court decision widely referred to in arguments, but seldom actually known about, Roe v. Wade. While many believe Roe v. Wade to be a case between a pregnant woman with the last name Roe fighting against the father of the child, last name Wade, to gain her right for an abortion, just about that entire summary is wrong. And most of what people believe about America's history with contraceptive rights is similarly flawed. Until the end of the 19th century, abortion, prior to the point where a woman could feel movements of the fetus inside her about the 4th month of the pregnancy, was legal in the United States. In fact, the earliest regulations related to abortion were from the 1820s and 1830s, and they were focused on dangerous drugs women were using to induce an abortion. Even though those drugs were sometimes fatal to the mother, they were advertised and sold to the public. In the 1850s, medical groups began calling for the criminalization of abortion. While most would assume this was because of the harm to the mothers caused by those dangerous drugs, time has shown that it was in part to protect the business of medicine, the business of doctors, from non-medical competition. If that isn't bad enough, others sought to criminalize it in hopes of increasing the white birth rate to counterbalance the growing immigrant population. In 1869, the Catholic Church formally banned abortion, and in 1873, Congress passed laws making it illegal to distribute contraception and abortion drugs in the United States mail. After all, that pesky mail is always interstate commerce. And by the 1880s, abortion was against the law across most of the United States. It wasn't until the 1960s and the women's movement, sometime later, that the court again faced cases regarding contraceptives. In 1965, the Supreme Court used privacy to strike down a law banning the distribution of birth control to those who were married. In 1970, Hawaii became the first state to legalize abortion for its residents and was joined by New York that same year, except New York dropped the in-state residency requirement. Within 2 more years, the Supreme Court extended that same privacy reasoning to the unmarried when it struck down a law prohibiting the distribution of contraceptive to unmarried people. By 1973 and the Roe case, abortion was only lawful in Hawaii, New York, Alaska, and Washington. With the backstory in place, who was Roe? Well, Roe wasn't Roe at all. It was 1969, and Roe was Norma McCorvey, a female resident of Texas in her early 20s. Roe had been pregnant twice before, and both times gave up her children for adoption. Roe wanted an abortion, but at that time, Texas only allowed abortions for the purpose of saving a mother's life. Keep in mind, women with money could travel to other countries or to New York to have an abortion, but McCorvey, or Roe, she didn't have that money. While other women in similar situations turned to dangerous illegal abortions, McCorvey was referred to Texas lawyers Linda Coffey and Sarah Weddington, who challenged the anti-abortion laws. And challenge them they did. They sued Wade, the dad. No, this case isn't about parental rights. Henry Wade was the district attorney for Dallas County, the county where Roe lived. And while maybe his name is most famous for Roe v. Wade, this is the same Henry Wade who prosecuted Jack Ruby, the man who shot Lee Harvey Oswald after his attack on then-President JFK. In June 1970, a Texas court ruled in favor of Roe, and the state's abortion ban was illegal as violating the same right to privacy we talked about before. The case eventually made its way to the highest court in all of the land, and the United States Supreme Court struck down the Texas law banning abortion in a 7-2 decision. Under the decision written by Ruth Bader Ginsburg, stop it, she wasn't even on the court yet, in a decision written by Harry Blackmun, an abortion was implicit in the privacy rights provided by the 14th Amendment by breaking the pregnancy into trimesters. Decisions in the first trimester were reserved to the woman alone. States were then allowed to regulate the second trimester, and states could ban outright a third trimester abortion altogether based on the fact that a fetus could survive on its own outside of the womb, unless the woman's health was in danger. So did Roe get her abortion? No, she didn't. She had her third child, and like the first two, she put her child up for adoption. Roe kept a low profile until the 1980s, when she became active in abortion rights movement. But then, in the mid-90s, she made some new friends, became Catholic, and turned into a vocal opponent of abortion. Similar to Roe, our nation remains divided on this topic. But our nation is not divided on hitting that subscribe button right over there and watching another episode of UNBILLABLE with me right down here.